Okay, we continue with our discussion on labor standards law. And we begin with workers not covered under the labor code. So these are the workers not governed by the labor code. Firstly, we have the government employees, including those under the employ of government-owned controlled corporations, which are governed by the civil service law or their charter. But if the employees of the GOCCs, no, but if the GOCC or the government-owned controlled corporation is incorporated under the corporation law, then it is governed by the labor code. So it should be an exception here in the note. Secondly, managers are not covered under the labor code. For those occupying high ranks, like treasurer, the vice president for finance, the president, and so on and so forth, including confidential employees, those who are spies, or the management or administrative staff who has the discretion to terminate employees. So these are not covered under the labor code. And also members of the family of the proprietors of the company, meaning the owners, their family members. The owner, the brother of the owner is not governed under the labor code, or the sister of the owner, or the son of the owner. Also not covered under the labor code are working scholars of schools, colleges, or universities, provided that the arrangement there is to grant the scholar a free tuition or free education. Then we have ambulant vendors. Who are ambulant vendors? These are the sellers of cigarettes, water bottles, bottled water on the streets. These are the ambulant vendors. They go everywhere. To question, are they, if somebody would say, I am an ambulant vendor selling bottled mineral water manufactured by Nature Spring for 20 years already. 20 years. I'm not selling anything but only bottled this water from Nature Spring. The question is that, is this vendor an employee of Nature Spring? The answer is no. Why? Because there's no control over this person. Nature Spring has no control. He goes there to sell bottled water on the street, depending on his time, depending on his availability. There is no control on the part of Nature Spring. You can sell anytime, or you can have day off anytime. So ambulant vendors are not governed by the labor code. Also, domestic servants like helpers or house helpers or any kind of helper of a person, or drivers, for instance. So these persons are domestic servants of another person. It's not covered by the labor code because they have their own law, kasambahay law. Who else? Those paid by commission. So if you work by commission, if you're a commission agent or a per piece worker, and you work in your own residence, provided you work in your own residence per piece, because there are per piece or piece rate employees or workers who are covered by the labor code, those who are working inside the premises of the employer. because there is supervision, no? Or those based on result of task accomplished, no? These are contractors. So these are not governed by the labor code, these persons. Likewise, drivers of jeepneys or taxi cabs who are renting the vehicle. So if the driver is renting the vehicle and then operates it, pays the rent, he's not covered under the labor code. But there are jeepney drivers or taxi cab drivers, including bus drivers and conductors, who are under the labor code. Those who are under the boundary scheme. So what is boundary scheme? Like for instance, you are the driver, then you drive the taxi cab. Once you reach a certain amount being agreed upon, let's say 1,000 pesos, that's the boundary. Then you are already given a salary and you can stop, or you can pursue driving. Though the boundary, once you reach the boundary, then everything being earned after the earning the boundary is already belongs already to the driver. So in that case, this type of driver is under the labor code, boundary system. But those renting, not under the labor code. Who else are not under the labor code? Employees of foreign governments who are here in the Philippines, or international organizations who are here in the Philippines. So these are the foreign government embassies, like the South Korea consulate, the US consulate here in Cebu, the Netherlands consulate, the Belgium consulate here in Cebu. So these Filipino workers employed by these governments are not covered under the labor code. Or international organizations like the International Rice Research Institute, which is based in somewhere in the Bicol region, or where is the UP Los Baños? Yeah, near that area, Los Baños area. So the International Rice Research is based here in the Philippines because we are #1 before in the production of rice. We are the best rice producers, but now we are overtaken by Vietnam, China, Thailand. Okay. Also, employees of other international organizations like the Red Cross, the WHO, World Health Organization, UNICEF, United Nations International Children's Fund, and so on and so forth. Then the resident physicians of hospitals who are covered by a training agreement or under a training program duly accredited or approved by appropriate government agency. So if the physician or the doctor is a resident and he's undergoing training, then he is not a regular employee. No? Without this agreements, he can be under the labor code. Then we have contractual employees as to principal. But the contractual employees are regular employees as to the contractor. Okay, so there are three parties here: the principal, the contractor, and the contractual employees. So the contractor is the one giving the employees to the principal. No, there is an agency, like a labor agency. So, but there are laws which have to be complied with here in order that the employees or the contractual workers will not fall directly as employees of the principal. Okay. And then we have the last group of workers, those who are working away from the office with hours of work in the field cannot be determined with reasonable certainty. These are also known as field personnel. So examples of field personnel are those selling encyclopedias. They're roaming around the area because the employer or the manufacturer of the encyclopedia has no control over these persons. Also common are those the what else? The collectors, no? Collectors of let's say vehicle, or those who are taking the meter reading of electricity meters, so they can go to work in the field without being known if they're working or not. So this type of workers are not covered under the labor code. Okay. Okay. So let's go to contractual employees. So there are requisites in order that they be legally hired. So the contractor, to validly deploy contractual employees to another person who is the principal, must comply with the following. Number one, the contractor must have substantial capital or has invested sufficient capital for capital stocks, equipment, implements, or tools, or office. No? So he must have an office. The contractor must give the contractual employees assignments, work assignments, or work roles or obligations performed by contractual employees which are not directly related to the main business of the principal. Because if the contractual employees are working directly, functions, roles, which are directly related to the main business of the principal, then these workers could fall as direct employees of the principal. No? Many cases has been decided on this matter, like the synergy workers against Philippine Airlines. They won. The synergy workers were contractual workers, were handling baggage acceptance and baggage loading in the aircraft, inside the aircraft of Philippine Airlines. So they take baggage, check in baggage, passengers, then load them to the aircraft. So they are contractual employees for like 15 years, and they filed a case with the Supreme Court. And the Supreme Court ruled that this type of employees are directly doing or performing work which is directly related to the business of Philippine Airlines. So they were regularized. So they won. Number three, the contractor does not exercise the right to control over the performance of the work of the contractual employee. Okay? Contractor does not exercise the right to control over the performance of the I think this is wrongly stated. The contractor exercises the right to control over the performance of the work of the contractual employee. It should be the contractor doing the control, because the principal, if the principal is the one exercising the right to control over the contractual employee's performance, then he is a direct employee to the principal. So it should be in the affirmative, not the negative. So Apologies for this one. So note, failure to comply any of the above shall make the contractual employees through a contractor illegal, which is now known as labor-only contracting. So if the contractor has no substantial or sufficient capital, no office, he could be labor-only contracting. So he's only a means to avoid for the principal to pay a higher wage or benefits. So it's a means to indirectly circumvent the law. So further, if proven, the contractual employees shall become part or shall become direct employees of the principal, but not to the contractor. So in this case, the principal shall be liable for all kinds of benefits to the workers. So these are the qualifications or requisites to be followed in hiring contractual employees. Also, there is that 6 months rule. No? If the contractual employees have rendered services to the principal for more than 6 months, what will happen? He becomes a regular employee. So that's why usually the contract of contractual employees is only from 5 months to not more than 6 months. So 5 months only, usually. Okay, let's go to another topic, which is recruitment and placement, also known as pre-employment. So recruitment and placement, what are these acts? So there is an acronym, which is CATCHUP. What are CATCHUP? CATCHUP is canvassing, enlisting, transporting, contracting, hiring, utilizing, or procuring workers. So if one is doing canvassing, enlisting, transporting, contracting, hiring, so you are already recruiting. It includes contract services, referrals, advertising for employment, promising for employment locally or abroad, whether for profit or not. You know? So if a person is doing catch-up and crap, and he is not receiving any fee, he is still doing recruitment and placement. So provided that any person or entity which in any manner offers or promises for a fee, employment to 2 or more persons shall be deemed engaged in recruitment and placement. Okay. This is very tricky, you know? Because there's what you call illegal recruitment of workers. What is illegal recruitment? It is a crime. And it is a result either of the following: performing any acts of recruitment and placement, which is catch up and crap, but without the authority or license issued by the POAE, which is the Philippine Overseas Employment Administration. POAEA. Or any person with license or not, my license, but commits any of the prohibited acts or practices stated Article 34. So what are these prohibited practices? LC means labor code. Number 1, to charge or accept directly or indirectly any amount greater than the specified in the schedule of allowable fees, no? Prescribed by the Secretary of Labor, or to make a worker pay any amount greater than that actually received by him as a loan or advance. Another, to furnish or publish any false notice or information or document in relation to recruitment or employment. In order to give any false notice, testimony, information, or document, or commit any act or of misrepresentation for the purpose of securing a license or authority under the law, or to induce or attempt to induce a worker who is already employed by another and to quit his employment in order to offer him another job, unless the transfer is designed to liberate the worker from oppressive terms and conditions of employment. So this involves a worker transferring from one employer to another